This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. Today, the United States Supreme Court, in a unanimous decision, has affirmed a lower court's ruling that Nautilus Productions cannot pursue its copyright claims against the state of North Carolina. Justice Kagan wrote for the court that the court's 1999 decision in a case called Florida Prepaid Post-Secondary Education Expense Board versus College Savings Bank, we're just going to call it Florida Prepaid, which invalidated the federal statute that sought to hold states monetarily liable for patent infringement, all but pre-wrote this decision by the court. In a separate concurrence, Justice Thomas questioned whether copyrights are properly within the original meaning of the 14th Amendment's due process clause. So we have something to do with the 14th Amendment, even though there is an article in the Constitution here, Article 1, Section 8, Clause 8. So, Section 8, 1, 2, 3, 4, 5, 6, 7, 8 has this little clause here that is the basis for everything that I do, to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. You would think that would apply to the states. We're going to see what happens there. Nautilus is the official videographer of Blackbeard's pirate ship, the Queen Anne's Revenge. They brought a lawsuit at the end of 2015 alleging that defendants made illegal copies, defendants being the state of North Carolina, illegal copies of Nautilus videography, and then persuaded the legislature to pass Blackbeard's law in an attempt to justify pirating decades worth of work created by Nautilus. Rick Allen, Nautilus owner, stated today under this Supreme Court ruling, writers, software developers, composers, filmmakers, and other creators just like me cannot avail themselves of the protection Congress gave them from copyright infringement by states. We are saddened by the court's decision. The state of North Carolina routinely and vigorously enforces its own copyrights, yet simultaneously hides behind sovereign immunity when it violates the intellectual property rights of its own citizens. The Constitution and Congress of the United States of America call for a different result. The Constitution expressly grants copyright holders the exclusive right to their copyrights and patents. Going forward, Nautilus will be evaluating all of its options. I don't know how many options are left there because there wasn't anything special about why they were allowed to violate just his copyrights. It appears to be any copyright, any patent can be completely violated by a state, and you can't do anything about it. The lawsuit arises out of the retrieval of Blackbeard's pirate ship. According to the complaint, the defendants were not content to use the videography as agreed and began making unauthorized copies, covering up their misconduct and passing and amending legislation to protect their infringement. Defendant, in addition to the governor and the state, includes employees of the Department of Natural and Cultural Resources and the Friends of Queen Anne's Revenge nonprofit. The Friends of Queen Anne's Revenge dissolved their corporation after the lawsuit was filed and are being defended by their insurance carrier. Nautilus has been the official video crew for Queen Anne's Revenge since 1998. They spent 20 years diving on the pirate shipwreck in dangerous conditions and documented archaeological activities and the recovery of artifacts from Blackbeard's infamous pirate ship for the benefit of and at zero cost to the taxpayers of North Carolina. The shipwreck was discovered by Intersul, which filed a separate lawsuit against North Carolina and the Friends of Queen Anne's Revenge that continues in state business court. So let's take a look at what the Supreme Court had to say. These are short pages, and we'll be getting through it fairly quickly here. So this is in the Supreme Court of the United States. This is the opinion of the justices of the Supreme Court. I believe it was a unanimous opinion. Let me take a quick look here. Okay, so Justice Kagan delivered the opinion. Let's highlight these. Justice Kagan, Roberts, Alito, Sotomayor, Gorsuch, Thomas. It seems like everybody concurs, so that seems to me to be a unanimous opinion. 1, 2, 3, 4, 5, 6, 7, 8, 9. Why do I see 10 here? Do we have 10? No, we don't have 10. We only have 9 on the Supreme Court. 1, 2, 3, 4, 5, 6, 7, 8, 9. Thomas. Thomas is there twice. Okay, so we've got a unanimous opinion of the Supreme Court. Let's take a look. Justice Kagan wrote this opinion. In two basically identical statutes passed in the early 90s, Congress sought to strip the states of their sovereign immunity from patent and copyright infringement suits. Not long after, this court held in the Florida prepaid decision that the patent statute lacked a valid constitutional basis. Today, we take up the copyright statute. We find that our decision in Florida prepaid compels the same conclusion. In 1717, the pirate Edward Teach, better known as Blackbeard, captured a French slave ship in the West Indies and renamed her Queen Anne's Revenge. The vessel became his flagship. Carrying some 40 cannon and 300 men, the Revenge took many prizes as she sailed around the Caribbean and up the North American coast. But her reign over those seas was short-lived. In 1718, the ship ran aground on a sandbar a mile off Beaufort, North Carolina. Blackbeard and most of his crew escaped without harm. Not so for the Revenge. She sank beneath the waters where she lay undisturbed for nearly 300 years. In 1996, a marine salvage company named Intersol discovered the shipwreck. Under federal and state law, the wreck belongs to North Carolina. But the state contracted with Intersol to take charge of the recovery activities. Intersol in turn retained petitioner Frederick Allen, a local videographer, to document the operation. For over a decade, Allen created videos and photos of divers' efforts to salvage the Revenge's guns, anchors, and other remains. He registered copyrights in all of those works. This suit arises from North Carolina's publication of some of Allen's videos and photos. Allen first protested in 2013 that the state was infringing his copyrights by uploading his work to its website without permission. To address that allegation, North Carolina agreed to a settlement paying Allen $15,000 and laying out the parties' respective rights to the materials. But Allen and the state soon found themselves embroiled in another dispute. Allen complained that North Carolina had impermissibly posted 5 of his videos online and used one of his photos in a newsletter. When the state declined to admit wrongdoing, Allen filed this action in federal district court. It charges the state with copyright infringement, call it a modern form of piracy, and seeks money damages. North Carolina moved to dismiss the suit on the ground of sovereign immunity. It invoked the general rule that federal courts cannot hear suits brought by individuals against non-consenting states. So what does that mean? It means that a state can only agree itself to invalidate or overcome sovereign immunity. So in other words, North Carolina would have to have a law on the books or some other avenue to overcome sovereign immunity in order for it to be sued. If the state did not make a law allowing it to be sued for copyright infringement, then you can't sue the state for copyright infringement. But Allen responded that an exception to the rule applied because the U.S. Congress had abrogated or overcome the state's sovereign immunity from suits like this through the Copyright Remedy Clarification Act of 1990, the CRCA, which provides that a state shall not be immune under the 11th Amendment or any other doctrine of sovereign immunity from suit in federal court for copyright infringement, and that is 17 U.S.C. 511A. And the act specifies that in such a suit, the state shall be liable and subject to remedies in the same manner and to the extent as a private party. That meant, Allen contended, that his suit against North Carolina could go forward. The district court agreed. Quoting the CRCA's text, the court first found that Congress has stated clearly its intent to abrogate state sovereign immunity for copyright claims. And that abrogation, the court held, had a proper constitutional basis. Florida prepaid and other precedent, the district court acknowledged, precluded Congress from using its Article I powers, including its authority over copyrights, to take away a state's sovereign immunity. What are they talking about there? This is Article I, Section 8, Clause 8. So that's Article 1, which describes the design of a legislative branch of government. So Florida prepaid decided that you can't use Article 1 powers to overcome state sovereign immunity. Let's see how the court deals with this. But in the district court's view, Florida prepaid left open an alternative route to abrogation. Given the state's pattern of abusive copyright infringement, Congress could accomplish its object under Section 5 of the 14th Amendment. On interlocutory appeal, which means in the middle of litigation, the Court of Appeals reversed. It read Florida prepaid to prevent recourse to Section 5 no less than to Article 1. So you can't go under the 14th Amendment, you can't go under Article 1 of the Constitution. The 14th Amendment is the amendment that gave due process federal violations, made that apply to the states. So if you have a Bill of Rights, you have certain constitutional rights that apply federally, well, now they also apply to the states. A Section 5 abrogation, the Fourth Circuit explained, must be congruent and proportional to the 14th Amendment injury it seeks to remedy. Florida prepaid had applied that principle to reject Congress' attempt in a Patent Remedy Act to abolish the state's immunity from patent infringement suits. In the Fourth Circuit's view, nothing distinguished the CRCA. So because Florida prepaid was Supreme Court precedent, and because it applied to the Patent Remedy Act, the same thing applied to the Copyright Remedy Act. That abrogation, the court reasoned, was equally broad and rested on a similar legislative record of constitutional harm. So Section 5 in the 14th Amendment could not save the law. Let's just take a look real quick. So Section 5 is a very generic clause, which just says that the Congress shall have the power to enforce by appropriate legislation the provisions of this article. The rest of it says that, all persons naturalized shall be subject to jurisdiction. No state shall make or enforce any law which shall abridge the privileges and immunities of the citizens, deprive a person of life, liberty, and property without due process of law. So there's the due process section. Nor deny to any person the equal protection of the laws. So they're saying that that Congress can make additional provisions through Section 5 to enforce Section 1. Because the Court of Appeals held a federal statute invalid, this court granted certiorari and we affirm, which means they're affirming what the Court of Appeals said, denying a remedy to plaintiffs Nautilus and Rick Allen. In our constitutional scheme, a federal court generally may not hear a suit brought by any person against a non-consenting state. That bar is nowhere explicitly set out in the Constitution. The text of the 11th Amendment, the single most relevant provision, applies only if the plaintiff is not a citizen of the defendant state. But this court has long understood that amendment to stand not so much for what it says as for the broader presupposition of our constitutional structure which it confirms. That premise, the court has explained, has several parts. First, each state is a sovereign entity in our federal system. Next, it is inherent in the nature of sovereignty not to be amenable to suit absent consent, or without consent. And last, the fundamental aspect of sovereignty constrains federal judicial authority. But not entirely. This court has permitted a federal court to entertain a suit against a non-consenting state on two conditions. First, Congress must have enacted unequivocal statutory language, abrogating the state's immunity from suit. Second, some constitutional provision must allow Congress to have encroached on the state's sovereignty. Not even the most crystalline abrogation can take effect until it is a valid exercise of constitutional authority. No one here disputes that Congress used clear enough language to abrogate state immunity from copyright infringement suit. As described above, the CRCA provides that states shall not be immune from those actions in federal court. And the Act specifies that a state stands in the identical position as a private defendant, exposed to liability and remedies in the same manner and to the same extent. So there is no doubt of what Congress meant to accomplish. Indeed, this court held in Florida Prepaid that the essentially verbatim provisions of the Patent Remedy Act could not have made any clearer Congress's intent to remove states' immunity. The contested question is whether Congress had the authority to take that step. Allen maintains that it did under either of two constitutional provisions. The first is Article 1, empowering Congress to provide copyright protection. It says exclusive right. If that fails, he invokes Section 5 of the 14th Amendment, which authorizes Congress to enforce the commands of the Due Process Clause. Neither contention can succeed. The slate on which we write today is anything but clean. Florida Prepaid, along with precedent, foreclose each of Allen's arguments. Congress has power under Article 1 to promote the progress of science and useful arts by securing for a limited time to authors and inventors the exclusive right to their respective writings and discoveries. That provision, which we call the Intellectual Property Clause, enables Congress to grant both copyrights and patents, and the monopoly rights so given impose a corresponding duty on states no less than private parties. Okay? In Allen's view, Congress' authority to abrogate sovereign immunity from copyright suits naturally follows. Abrogation is the single best, or maybe he says the only way, for Congress to secure a copyright holder's exclusive rights against a state's intrusion. So Allen contends the authority to take that step must fall within the Article 1 grant of power to protect intellectual property. The problem for Allen is that this court has already rejected his theory. The Intellectual Property Clause, as just noted, covers copyrights and patents alike, so it was the first place the Florida Prepaid Court looked when deciding whether the Patent Remedy Act validly stripped the states of immunity from infringement suits. In doing so, we acknowledged the reason for Congress to put states on the same footing as private parties in patent litigation. It was, just as Allen says here, to ensure uniform, surefire protection of intellectual property. That was a proper Article 1 concern we allowed, but still, we said Congress could not use its Article 1 power over patents to remove the state's immunity. We based that decision on a previous case, Seminole Tribe versus Florida, decided 3 years earlier. There, the court had held that the Article 1 powers cannot be used to circumvent the limits of sovereign immunity placed upon federal jurisdiction. That proscription ended the matter. Because Congress could not abrogate state sovereign immunity under Article 1, Florida Prepaid explained the Intellectual Property Clause could not support the Patent Remedy Act, and to extend the point to this case, if not the Patent Remedy Act, not its copyright equivalent either, for the same reason. Here, too, the power to secure an intellectual property owner's exclusive right under Article 1 stops when it runs into sovereign immunity. Allen claims, however, that a later case offers an exit ramp from Florida Prepaid. In Central Virginity Community College versus Katz, we held that Article 1's bankruptcy clause enables Congress to subject non-consenting states to bankruptcy proceedings, there to recover a preferential transfer. In other words, someone transferred money to a creditor outside of the rules of bankruptcy. We thus exempted the bankruptcy clause from Seminole Tribe's general rule that Article 1 cannot justify hailing a state into federal court. In bankruptcy, we decided sovereign immunity has no place. But if that's true, Allen asks, why not say the same thing here? Allen reads Katz as adopting a clause-by-clause approach to evaluating whether the particular clause of Article 1 allows the abrogation of sovereign immunity. And he claims that the Intellectual Property Clause supplies singular warrant for Congress to take that step. That is so, Allen reiterates, because Congress could not secure authors' exclusive right to their works if it were powerless to make states pay for infringing conduct. But everything in Katz is about and limited to the bankruptcy clause. The opinion reflects what might be called bankruptcy exceptionalism. In part, Katz rested on the singular nature of bankruptcy jurisdiction. That jurisdiction is and was at the founding principally in rem, meaning that it was premised on the debtor and his estate, not on the creditors. For that reason, we thought it does not implicate state sovereignty to nearly the same degree as other kinds of jurisdiction. In remaining part, Katz focused on the bankruptcy clause's unique history. The clause emerged from a felt need to curb the state's authority. The states, we explained, had wildly divergent schemes for discharging debt and often refused to respect one another's discharge orders. The framers' primary goal in adopting the clause was to address that problem, to discourage competing sovereigns from interfering with a debtor's discharge. And in that project, the framers intended federal courts to play a leading role. The nation's first Bankruptcy Act, for example, empowered those courts to order that states release people that they were holding in debtor's prison. So through and through, we thought the Bankruptcy Clause embraced the idea that federal courts could impose on state sovereignty. Indeed, it was sui generis, again unique among Article 1's grants of authority. Indeed, Katz's view of the bankruptcy clause had a yet more striking aspect, which further separates it from any other. The court might have concluded from its analysis that the clause allows Congress to abrogate the state's sovereign immunity, as Allen argues, but it did not. It instead went further. Relying on the above account of the framers' intentions, the court found that the bankruptcy clause itself did the abrogating. The relevant abrogation is the one affected in the plan of the Constitutional Convention. Or, stated another way, we decided that no congressional abrogation was needed because the states had already agreed in the plan of the convention not to assert any sovereign immunity defense in bankruptcy proceedings. So in other words, the bankruptcy was fully considered during the Constitutional Convention, I guess. We therefore discarded our usual rule, which Allen accepts as applying here, that Congress must speak, and indeed speak unequivocally, to abrogate sovereign immunity. Our decision, in short, viewed bankruptcy as on a different plane, governed by principles all its own. Nothing in that understanding invites the kind of general clause-by-clause re-examination of Article 1 that Allen proposes. To the contrary, it points to a good-for-one-clause only holding. And even if Katz's confines were not so clear, Florida prepaid, together with stare decisis, or the observance of legal precedent, would still doom Allen's argument. As Allen recognizes, if the Intellectual Property Clause permits the CRCA's abrogation, it would also permit the Patent Remedy Acts. Again, there is no difference between copyrights and patents under the clause, nor any material difference between the two statutes' provisions. So we would have to overrule Florida prepaid if we were to decide this case Allen's way. But stare decisis, this court has understood, is a foundation stone of the rule of law. To reverse a decision, we demand a special justification over and above the belief that the precedent was wrongly decided. Allen offers us nothing special at all. He contends only that if the court were to use a clause-by-clause approach, it would discover that Florida prepaid was wrong because, he says again, the decision misjudged Congress authority under the Intellectual Property Clause. And with that charge of error alone, Allen cannot overcome stare decisis. So the court is relying on its own precedent and saying, we're not going to overturn previous precedent without something more from Congress, I guess. Section 5 of the 14th Amendment, unlike almost all of Article 1, can authorize Congress to strip the states of immunity. The 14th Amendment fundamentally altered the balance of state and federal power that the original Constitution and the 11th Amendment struck. Its first section imposes prohibitions on the states, including that none may deprive any person of life, liberty, or property without due process of law. Article 5 then gives Congress the power to enforce by appropriate legislation those limitations on states' authority. That power, the court has long held, may enable Congress to abrogate the states' immunity and thus subject them to suit in federal court. For an abrogation statute to be appropriate under Section 5, it must be tailored to remedy or prevent conduct infringing the 14th Amendment's substantive prohibitions. Congress can permit suits against states for actual violations of the rights guaranteed in Section 1, and to deter those violations, it can allow suits against states for a somewhat broader swath of conduct, including acts constitutional in themselves. But Congress cannot use its enforcement power in the 14th Amendment to alter what that amendment bars. That means a congressional abrogation is valid under Section 5 only if it sufficiently connects to conduct courts have held Section 1 to prescribe. So in other words, only if the conduct falls within that Section 1 that we saw, granting the due process and other rights, can they prescribe or abridge or abrogate state sovereign immunity using the 14th Amendment. To decide whether a law passes muster, this court has framed a type of means-end test. For Congress's action to fall within its Section 5 authority, we have said, there must be a congruence and proportionality between the injury to be prevented or remedied and the means adopted to that end. I mean, so far, sounds normal to me that copyright would fall within this. Congruence and proportionality. I mean, what more do you want? That the state was taking his copyrighted content and just using it for themselves, completely infringing, no apologies. They even passed a law to say that it was legal. On one hand, courts are to consider the constitutional problem Congress faced, both the nature and the extent of state conduct violating the 14th Amendment. That assessment usually, though not inevitably, focuses on the legislative record, which shows the evidence Congress had before it of constitutional wrongdoing. On the other hand, courts are to examine the scope of the response Congress chose to address that inquiry. Here, a critical question is how far and for what reasons Congress has gone beyond redressing actual constitutional violations. Hard problems often require forceful responses, and, as noted above, Section 5 allows Congress to enact reasonably prophylactic legislation to deter constitutional harm. But strong measures appropriate to address one harm may be unwarranted as a response to another lesser one. Always, what Congress has done must be in keeping with the 14th Amendment rules it has the power to enforce. All this raises the question: when does the 14th Amendment care about copyright infringement? Sometimes, no doubt, copyrights are a form of property, and the 14th Amendment bars the states from depriving a person of property without due process of law. But even if sometimes, by no means always. Under our precedent, a merely negligent act does not deprive a person of property, so an infringement must be intentional, or at least reckless, to come within the reach of the Due Process Clause. And more, a state cannot violate that clause unless it fails to offer an adequate remedy for an infringement, because such a remedy itself satisfies the demand of due process. That means, within the broader world of state copyright infringement is a smaller one where the Due Process Clause does come into play. Because the same is true of patent infringement, Florida Prepaid again serves as the critical precedent. That decision defined the scope of unconstitutional infringement in line with the case law cited above as intentional conduct for which there is no adequate state remedy. It then searched for evidence of that sort of infringement in the legislative record of the Patent Remedy Act, and it determined that the statute's abrogation of immunity, again equivalent to the Copyright Remedy Act, was out of all proportion to what it found. That analysis is the starting point of our inquiry here. And indeed, it must be the ending point too, unless the evidence of constitutional infringement is materially different for copyrights than patents. Consider once more then Florida Prepaid, now not in Article 1, but in Section 5 of the 14th Amendment. In enacting the Patent Remedy Act, Florida Prepaid found Congress did not identify a pattern of unconstitutional patent infringement. To begin with, we explained, there was only thin evidence of states infringing patents at all, putting aside whether those actions violated due process. The House report, recognizing that many states comply with patent law, offered just 2 examples of patent infringement suits against states. The appellate court below, boasting some greater research prowess, discovered another 7 in the century plus between 1880 and 1990. Even the bill's House sponsor conceded the lack of any evidence of widespread violations of patent laws. What was more, there was no evidence that any instance of infringement by states crossed constitutional lines. Congress, we observed, did not focus on intentional or reckless conduct. To the contrary, the legislative record suggested that most state infringement was innocent or at worst negligent. And similarly, Congress barely considered the availability of state remedies for patent infringement, so we concluded nothing could support the idea that states were more than sporadically, if that, depriving patent owners of property without due process of law. Given that absence of evidence, Florida Prepaid held, the Patent Remedy Act swept too far. Recall what the Patent Remedy Act did and did not. It abrogated sovereign immunity for any and every patent suit, thereby placing states on the same footing as private parties. It did not set any limits. It did not, for example, confine the abrogation to suits alleging non-negligent infringement or infringement authorized by state policy. Neither did it target states refusing to offer alternative remedies to patent holders. No, it exposed all states to the hilt on a record that failed to show that they had caused any discernible constitutional harm or indeed much harm at all. That imbalance made it impossible to view the legislation as responsive to or designed to prevent unconstitutional behavior. The statute's indiscriminate scope was too out of proportion to any due process problem. It aimed not to correct such a problem, but to provide a uniform remedy for patent infringement at large. The Patent Remedy Act, in short, did not enforce Section 1 of the 14th Amendment, and so was not appropriate under Section 5. Could then this case come out differently? Given the identical scope of the CRCA and Patent Remedy Act, that could happen only if the former law responded to a materially stronger evidence of infringement, especially of the unconstitutional kind. Allen points to a significant disparity in how Congress created a record for the two statutes. Before enacting the CRCA, Congress asked the then Register of Copyrights, Ralph Oman, to submit a report about the effects of the 11th Amendment on copyright enforcement. Oman and his staff conducted a year-long examination, which included a request for public comments eliciting letters from about 40 copyright holders and industry groups. The final 158-page report concluded that copyright proprietors have demonstrated they will suffer immediate harm if they are unable to sue infringing states in federal court. Is that report enough, as Allen claims, to flip Florida Prepaid's outcome when it comes to copyright cases against the states? It is not. Behind the headline-grabbing conclusion, nothing in the Oman report or the rest of the legislative record cures the problems we identified in Florida Prepaid. As an initial matter, the concrete evidence of states infringing copyrights, even ignoring whether those acts violate due process, is scarcely more impressive than what the Florida Prepaid court saw. Despite undertaking an exhaustive search, Oman came up with only a dozen possible examples of state infringement. He listed 7 court cases brought against states, with another 2 dismissed on the merits, and 5 anecdotes taken from public comments but not further corroborated. In testifying about the report, Oman acknowledged that the state infringement is not widespread, and the states are not going to get involved in wholesale violation of copyright laws. Instead, he opined, they are all respectful of the copyright law and will continue to respect the law. What state, after all, would want to get a reputation as a copyright pirate? Apparently North Carolina. The bill's House and Senate sponsors got the point. The former admitted that there have not been any significant number of copyright violations by states. So in other words, we have to see some, wrongdoing from the states before we can make a law against it. You couldn't make a law against murder before somebody gets murdered. You can't make a law against drunk driving until somebody is just driving drunk, is my analogy here, which makes 0 sense to me. Absolutely 0 sense, but I'm going to let the court continue. And the latter conceded he could not currently see a big problem. This is not, to put the matter charitably, the stuff from which Section 5 legislation ordinarily arises. And it only gets worse. Neither the Oman report nor any other part of the legislative record shows concern with whether the state's copyright infringements violated the Due Process Clause. Of the 12 infringements listed in the report, only 2 appear intentional, as they must be to raise a constitutional issue. As Oman testified, the far greater problem was the frequency of honest mistakes or innocent misunderstandings. The benefit of the bill, he therefore thought, would be to guard against sloppiness. Likewise, the legislative record contains no information about the availability of state law remedies for copyright infringement, even though they might themselves satisfy due process. Those deficiencies in the record match the ones Florida Prepaid emphasized. Here, no less than there, they signal an absence of constitutional harm. And yet the guy is suing over an act of intentional copyright infringement. Like, the court is ignoring what's directly in front of them, the evidence of a plaintiff suing a defendant state for intentional copyright infringement that seems pretty obvious and clear. Yet they're saying that because Congress didn't have that record in front of them back when they created the CRCA, that today's plaintiff can't have a remedy. Under Florida Prepaid, the CRCA thus must fail our congruence and proportionality test. As just shown, the evidence of 14th Amendment injury supporting the CRCA and the Patent Remedy Act is equivalent. For both, that is, exceedingly slight. and the scope of the two statutes is identical, extending to every infringement case against a state. It follows that the balance of laws strike between constitutional wrong and statutory remedy is correspondingly askew. In this case, as in Florida prepaid, the law's indiscriminate scope is out of proportion to any due process problem. In this case, as in that one, the statute aims to provide a uniform remedy for statutory infringement rather than to redress or prevent unconstitutional conduct. Again, you can't say, and the court would not say that you can't make a law against murder until somebody gets murdered. I don't understand why you can't proscribe or prohibit copyright infringement by the states the same way you do with individual citizens, unless you can first identify that the states are doing something that would be considered copyright infringement otherwise. It's kind of a chicken and egg problem. The court is saying that, well, you can't have a chicken without an egg, and since we haven't seen an egg, how could there be a chicken? But that's not quite how animals evolve, and you don't just one day wake up and there's just an egg and it turns into a chicken. It's an evolutionary process. So the court's saying that, well, we didn't see the chicken before the egg, or we didn't see the egg before the chicken, so therefore you couldn't possibly have a chicken or an egg, even though I'm staring at a chicken that came from an egg right now in this particular case. It's very strange. It seems to me like they're just pulling the wool over their eyes and being like, I don't see anything. Congress has to see something first. It's really weird. This is a really weird opinion, and it's unanimous. So all the justices agreed that this is the way we get rid of any sovereign immunity problem. That conclusion, however, need not prevent Congress from passing a valid copyright abrogation law in the future. Okay, so there's hope. There's a silver lining. In doing so, Congress would presumably approach the issue differently than when it passed the CRCA. At that time, the court had not yet decided Seminole Tribe, so Congress probably thought that Article 1 could support its all-out abrogation of immunity. And to the extent it relied on Section 5, Congress acted before this court created the congruence and proportionality test. For that reason, Congress likely did not appreciate the importance of linking the scope of its abrogation to the redress or prevention of unconstitutional injuries, and of creating a legislative record to back up that connection. But going forward, Congress will know these rules, and under them, if it detects violations of due process, then it may enact a proportionate response. That kind of tailored statute can effectively stop states from behaving as copyright pirates. Even while respecting constitutional limits, it can bring digital Blackbeards to justice. Florida prepaid all but pre-wrote our decision today. That precedent made clear that Article 1's intellectual property clause could not provide the basis for an abrogation of sovereign immunity, and it held that Section 5 of the 14th Amendment could not support an abrogation on a legislative record like the one here. For both reasons, we affirm the judgment below, which is just mind-blowing. It's in the plain language of the statute, as Rick Allen's team pointed out. The Congress has the authority to grant the exclusive rights to copyright holders and patent holders as well. So how could it be more clear? Exclusive means exclusive, does it not? But the Supreme Court came up with something here saying that you need something more tailored to the actual willful infringement in order to abrogate state sovereign immunity. So it seems like, going forward, if somebody can convince Congress to overhaul the Patent Remedy Act and the Copyright Remedy Act, that there could be an amendment that makes legislative findings and makes a legislative record documenting the infringement that does occur, and then making a more tailored law to address specifically the willful infringement as opposed to the accidental or negligent infringement. I think it's unnecessarily complicating something. When an individual citizen commits an act of copyright or patent infringement, it is often a strict liability offense. You're liable for the offense if you committed the act, whether you meant to or not. So it's interesting that the states then have a right to get around the U.S. Constitution, which they all ratified, basically agreeing to obey. It's right there in the plain language of the text. I think the court is nuts, but it's a unanimous opinion. I mean, you don't really get any stronger than that. And as Justice Robert H. Jackson said, we are not final because we are infallible, but we are infallible only because we are final. Meaning, that's the final decision of the court, and we have to take it. There's nothing that we can do about that decision except go back to Congress and try to accommodate the court's decision, like I said, with some kind of tailored legislative record and a more tailored law that addresses the willful infringement. And that's it. That's what you get. You don't get anything more than that from the court. The only thing I have to add is that I did reach out to Rick, to Mr. Allen, and he replied to me, and he had some very nice things to say. He says, "We are well, and I hope you and your family are well. Press release attached," which we looked at in the beginning. And I asked him if he was surprised by the result or if they expected it. He says, "We were surprised by the result. I think that anyone with intellectual property rights should think long and hard about partnering with a state agency at this time. In my case, North Carolina literally passed a law to justify the misuse of my intellectual property. The fact that states now have carte blanche to infringe copyrights with impunity should give every writer, artist, software designer, or documentarian pause. You'll be seeing some of my Queen Anne's Revenge footage on the National Geographic and Smithsonian channels in the near future, so check those out. You might also see some of my sand tiger shark footage during Shark Week. Feel free to link to my footage here. I'm posting a link in chat, so there's some of his footage if you want to see what he does." And he says, "Feel free to contact me or my team. All the best, Rick." So thank you to Mr. Allen for replying to me. Really appreciate that. And I'm not even sure that not contracting with a state would really do anything. This seems to allow the states to commit copyright and patent infringement with impunity, with immunity, with no remedy, whether you've contracted with them or not. So maybe don't contract with them because there's nothing that you can do if they break their contract or commit copyright infringement or patent infringement. But there's also nothing you can do if you go out and take some beautiful pictures and they just post them on their website and use them as backgrounds. Or, I mean, heck, a state could decide that they need to increase their revenue, so they open up a YouTube channel reposting Lawful Masses videos, and there'd be nothing that Lawful Masses could do about it, is basically what this says. There's no remedy against the state. So, I mean, states are pretty creative in coming up with various taxes and penalties and avenues to revenue. So why couldn't a state just open up a YouTube channel posting other people's intellectual property, getting millions of subscribers, and then keeping all the revenue for themselves? I don't see how this is an outcome that the Supreme Court can endorse when there is literally a constitutional clause. The constitutional clause that all of the states ratified should apply, in my opinion. So I guess I disagree with 9 justices of the Supreme Court. And who am I? So I don't know what effect that has. Even if you did give DMCA takedown notices, yeah, maybe YouTube would have to remove them so YouTube stays in their safe harbor. But what if the state set up a server farm and served the videos out of their own server farm and over their own internet connection? I don't know. Yeah, it's like slavery with extra steps. So yeah, that's an interesting one. Let me know what you think in the comments below. It was a bit confusing. I tried to distill it down for you. If you're still confused, also feel free to ask your questions in the comments, and we'll all try to figure it out together. There were 2 concurring opinions there that I didn't go over. If anybody wants to see those, I'll link to the document on lawfulmasses.com and on Patreon and sponsors. All right, that is our show, everyone. Thank you very much for joining me. This is Lawful Masses, your favorite legal news and education channel, and I'm Leonard French, your favorite copyright attorney. This channel would not exist without your financial support, and I'm very grateful to those of you who are supporting us in the month of March. Thank you to the $50 plus supporters: Wes Delj, Aspernari, Video Remonetized, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Michael Pearce, Spirit Bear, Jan Negrey, Daniel Perez, Blackleaf, Joe Tyson, Benjamin Hitov, Stephen, Ottah, Cute Grills in Your Area, Longreach Jones, Zachary Chaney, Mullen PC, and Anders Thorenfeldt. And thank you to all the $5 plus supporters. Everyone's scrolling on that LED panel behind me, and you'll be in the description of the videos below. We're getting ready to switch over to April, so if you want to be on the April supporter lists, make sure that you get your pledge set up on patreon.com/ljfrench or sponsors.com/law before the 1st of April. My birthday is March 31st, and I'll be doing a special March 31st live stream. I'm turning 40, so I figure I can't have my birthday party out. We're gonna have a birthday party here together. I don't even know that I can go out and get any decorations. So yeah, it'll just be a very plain 40th birthday party for me. A very merry unbirthday for me. So anyway, thank you very much for your support. Thank you for watching. Thank you for joining me. I love you all. Stay safe, stay healthy, wash your hands, observe your social distancing practices, and I will see you in the videos that drop. I love you all. Bye. Hello. Yeah, Kaylee gave me this hat last year for my birthday. So I thought it would. Oh, hello. Am I ignoring you? Am I ignoring you? Did you had to pee so badly that you didn't say hi at first? What a good boy. Jeez, you guys move around so fast. It's hard for me to keep up with the camera.